fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as you. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Today is Judge Phyillis Webster of Kansas. I like this lady. This judge definitely deserves some respect. Share screen. Back to StreamYard. Make this bigger.
Additionally, with what you told me today, I would think that the defendant might be afraid of you making false reports on him, that if he comes around you.
Judge, this is a case where after talking with Mr. Swank, we are asking to have it set for a jury trial. Further, Judge, I would tell the court the named alleged victim in this case, who is Angela Brown Judd, was just in my office. She is wanting to appear here today. We did give her the email for the Zoom link. I don't know if she's appeared in the waiting room or not. I think she wants to appear in reference to a request to lift the GPS unit and also lift the no contact order.
Okay, Jen, have you seen someone identifying herself as Angela Brown -Judd, Judd?
I do have someone in the waiting room labeled iPhone. I have sent them a message, but they have not responded.
That's probably her. I'm not sure how good she is at the Zoom stuff, Judge.
Well, you know why we have this rule, Mr. Patterson.
I do. I understand fully, Judge. I don't know if the court wants to put this to the hill of the docket or.
Well, let's take a chance, and I'll.
Should these glasses
have to bear the brunt if it's a mistake to do so. And of course, I'll come back on you, Mr. Patterson, as much as I have to answer. So
All's on me. I
all
understand.
right. So Jen, take a chance and bring her in. Don't know why they won't identify when they're told to, but okay. Is Angela Brown Judd present? I'm still not seeing her.
Yes.
Are you? Okay,
That is her, Judge.
okay, you're Angela Brown Judd, is that right?
Yes.
And you are appearing today as an alleged victim in State of Kansas versus Justin Dannon Swank, is that correct?
Yes, ma'am.
And he is charged with theft of a truck and key rings belonging to you and criminal damage in a value less than $1,000, in which you're the alleged victim.
Yes.
These crimes allegedly occurring April 17th and the 18th of 2025. What is it you want to be heard on, please?
Well, I know that
Well, before
I
you answer
didn't.
that, excuse me, before you answer that, what's your relationship, if any, to the defendant?
That's my husband.
He is your husband. Okay.
Yes.
Was he her husband on April 17th and 18th of 2025?
Yes.
All right. So go ahead, please.
Okay, so I kind of explained I do have some mental health problems that have been addressed most of my life. The issue with Justin is I acted out. As far as the truck's in his name. He does have the title in his possession. I have a brand new $1,400 iPhone that I'm holding in my hand now. And it was probably more of my fight on dropping the phone. The phone wasn't even worth $100, honestly, when we went and put it in a machine. So, I just don't, the truck's in his name now. It's his possession. I don't know any further. I mean, he is my mental health. He's over me with my SSI, my Social Security. He is
He's
my
what they call
caretaker.
Your payee.
He's my payee and my caretaker. It's my mental health stability. He's been my best friend since 2000. And I think a lot of it was my mental health acting out. And, I'm trying to work on that. I've started some new meds. But I put him in a situation that, we barely just bought our house. This ankle monitor is eating up, $300 a month. As I said, I'm on disability.
Excuse me. How do you know how much the ankle monitor is costing?
Oh, trust me, I've been on ankle monitors more times than you probably put people on ankle monitors, ma'am.
So you haven't talked with him about how much he's paying on the ankle monitor?
No, ma'am. But I've been on ankle monitors probably more times than you've issued it in your courts.
Are you paying for that out of your disability, his ankle monitor?
No, I'm not paying for that out of my disability. But regardless, I mean, disability isn't enough to pay for something like that. But regardless of what it is, I mean, what is the point of an ankle monitor? I don't see whose butt it's saving. Yours, mine, his. What is the ankle monitor doing for him anyway?
Well, before you started talking today, I would have said it's for your benefit, but now it sounds like it's for his as much as for yours. If you're coming on here telling me that you set him up, it was you that dropped the phone and damaged it, and that it was your mental health that caused him to be in this case, that makes it sound like maybe he needs protection from false allegations if you're wanting to take that route and say these are all false and your responsibility. I'd say the ankle monitor is to protect you both so you can't later say he came around you if he didn't.
Okay, he needs to be around me. That's my stability, my mental stability. That's how I get to my appointments. That's how you know what I'm saying? I don't function well without him. And I haven't functioned well without him since 2001.
All right. So you're basically here to ask me to lift the no contact between the two of you. Is that right?
Yes. And whatever else.
And to remove his ankle monitor to keep him in line with his relationship with you. You want the ankle monitor off of him too, right?
Well, I mean, that would make sense. I mean, he's paying for something for what? I just for the benefit of what? There's that an ankle monitor doesn't protect anything. The things that I did on an ankle monitor, you could only imagine. So,
All right. Thank you, ma'am. Thank you, Miss Swank. Does any attorney want to be heard on this
Yes,
request?
Judge,
Mr. Patterson, why don't you go first?
Okay.
Judge, this is a case where I have spoke to my client. It is a case where we are asking to have a jury trial date set, but also based upon statements of Ms. Brown Judd, as well as my client would ask the court to remove the ankle monitor, the GPS. It is costing a lot of money, and asking to allow the contact and lift the no contact order. Thank you.
Mr. Regier?
One moment, Your Honor. As a preliminary matter, the state would have it noted on the record that the issue of lifting the no contact or the GPS monitor does not appear to be properly before the court. The state is not aware of any formal written motions having been filed with the court, so I am at somewhat of a disadvantage in this case. If the court is prepared to determine that that issue is properly before the court, the state would object to any modifications in prior bond conditions at this time. This is a case that appears to have multiple counts with domestic violence designations attached to the same. Notwithstanding any statements made on the record, this is a defendant with a history of prior convictions that the state considers relevant. If the court wishes me, I can go into those briefly. But again, the state's position, at least from the offset, is that this issue is not properly before the court, and if the court is prepared to take it up, the state would adamantly object to it.
You object to taking up the issue at this time?
That would be the state's first objection, Your Honor.
Well, I think we're a little late for that because we've already started taking it up. I understand where you're coming from, though, that you're surely perhaps blindsided, maybe not. Maybe the alleged victim has been to your office and made these statements before. Maybe she hasn't.
Your Honor, may I please speak?
One last time before I make a ruling. Go ahead.
I did write a letter to their office, to Miss Sarah Green. I did come in and speak with her again after the incident happened. I do have documentation that like a lot of my appointments he is present on.
This bra is for seniors who want to get back.
You know, I've tried to give them as much information as I can. I've tried to provide them with whatever. I have emails between me and Miss Green. You know, I don't know what else to further say on this issue. He
objects. Not to say anything further, okay?
Yes,
I understand what I hear what you're saying. I don't think you need to keep trying to put it into words.
Yes,
I will tell you that with domestic violence victims, any of us that have worked with them with very much period of time, we know that even if you don't have an unhealthy mental health background coming into them, they can be very troublesome. They can play havoc with your judgment. And that's why the courts and counsel have the responsibility for setting up measures to try to protect you from what you may not know is involved with what you're asking. And so we put those protections in place for primarily the alleged victims, because we don't go looking for you and your husband to pick on or pull, separate. We get involved because whatever's happened between you has caused law enforcement to become involved. And I'm sure if you go back to the county attorney's victim witness provider, she can explain to you in more detail and better than I can in a short period of time why it's important to protect victims, alleged victims who may not even realize they need protection. That can happen with children. That can happen with domestic violence victims because they just don't understand everything that's involved. We don't understand everything involved, but if we've been through this enough times with others, we kind of start getting some familiar patterns to deal with. So, first of all, Mr. Regier is right. There isn't a formal motion to modify the bond conditions. Second of all, even if there were, I am not sure that I have from you any kind of safety plan prepared from a safe house or a therapist to show that what you're proposing would be a protective measure. And then additionally, with what you've told me today, I would think that the defendant might be afraid of you making false reports on him, that if he comes around you, what's to say he's not going to get the police called on him again and be charged with more and more serious charges even. I don't know which one of you's done something wrong. If either of you, that's for the jury to decide that Mr. Patterson has asked for. They will hear both of your evidence, both of you maybe. They'll hear from Mr. Regeer's evidence, including you or not with you. Mr. Patterson will have the opportunity to present his client if he wants or any other evidence. But that's going to be for the jury to decide. I will grant a jury trial. Jen, when's our next jury trial? I've forgotten.
Pre-trial is February 23rd, Your Honor, with jury trial beginning February 25th.
February 23rd is pre-trial. February 25th is jury trial. We don't have any in October this year.
Waste of money.
You do have one coming up with pre-trial. It'll be in September 29th. I was just concerned that that would not be enough time to prepare.
That would be the state's concerns as well, Your Honor.
Understood. Okay. All right. So the next available, I will set this, Mr. Patterson, at the defendant's request for jury trial. I trust you'll be filing appropriate documentation.
Yes.
February 23rd at 9 a.m. will be the pre-trial by Zoom. Actual jury trial will be February 25th, live in person at the courthouse, Mr. Swank. And those are both in the year 2026. Ms. Swank will get a subpoena if necessary to be present for that from the state. Okay, so that's the first order of request today, is to set this over for jury trial. The next is I am not going to allow contact without further mental health experts. And that's not only just to protect you physically, Ms. Swank, but to protect Mr. Swank from any false allegations. I don't know what's right and wrong. I have heard bits and pieces, but the jury will hear it all in February and they will decide.
So what would you like from who?
Well, go back to the county attorney and talk to them more.
He's an idiot.
Or you go hire a witness. You go hire an attorney of your own if you don't think you're getting what you need there. But you see, you have victims' rights, and that's why I'm letting you speak today, even though there's not a motion on file, because I believe that you do have the right to be heard even without a motion on file. And that's why we're taking this up briefly today. But if we're going to take it up any further, you're going to need to get an attorney or go back to the county attorney and let them represent you on this motion. So that's what I'm going to direct you to do. And we can take that up February 23rd or sooner if the parties or an attorney want to ask for an earlier date on that sole issue of bond modification.
So there's no specific thing that you want for the courts from my doctor?
I'm not going to tell you how to present your case. I want you to get with an attorney and let them present their own case.
All right.
Okay. All right. If there's nothing further, counsel, Mr.
From the
Regeer,
state, Your Honor.
Mr. Patterson.
Nothing further today, Judge.
All right. Thank you all for your time. We'll be in recess at the Swank, and anyone here to just on Swank is excused.
What you want to do is save hundreds with Liberty Mutual.
This weird scissor
One, State of Kansas versus Dale Eugene Luganbill. County Attorney Jared Regeer for the state. Defendant in person via Zoom. Mr. Luganbill, you were supposed to be here at 9 o'clock. You've just logged on at 10:05. And on May 5th, Judge Crum saw you and told you to appear in person at the courthouse. Why aren't you at the courthouse?
I thought it was tomorrow. I've been talking to attorneys. There is no way I can afford an attorney. There's a lot more money.
How did you? Okay, sir, but why aren't you at the courthouse? You're in violation of Judge Crumb's orders.
I thought tomorrow was the 15th. I was positive of it.
How did you figure out today was the 15th?
I asked my phone what today's date was, and it said the 15th. I said, "Oh my God!"
And your phone, but your phone did confirm that it was the 15th.
Yes, ma'am.
Well, good for your phone.
Today is the 15th, and you have court, old man.
Now, why did you violate Judge Crumb's other order and not go out and set a $2,000 bond?
Well, I tried to, but the gnats come up and covered it. He didn't have no sound. I couldn't hear what he's saying because there's no sound either way. He wrote a note and told me, and I pushed back up to delete it, and it hung up. And I've been having vehicle problems. I haven't had a vehicle in 2 months. I got it going now.
Maybe, sir, maybe I can solve your problems. I can have an officer go pick you up and bring you to jail and keep you there until we get these hearings taken care of. They can feed you, they can air condition you, they can give you a nice bed to sleep in, and they can make sure that you don't miss court.
Yes, ma'am. I apologize for missing court. I swear to God, if I knew it was today, I've got my truck going. I bought another junk truck, and I took parts off of it.
Sir, you have got more excuses.
No, ma'am.
May 15th, we told you you had to appear, and you hung up because you wanted to schedule your court.
I did not hang up. I pushed back up on the phone and tried to get rid of the app that was covering the picture, and it hung up.
Let me talk to you a minute, and you listen. May 15th of 2024, you called and said you needed to reschedule your court date. And you were told that at that last minute, you couldn't do that. You had to appear. So you hung up on the clerk. Then you did come in May 15th. I don't think it was in person, but you were in front of Judge Crumb, and he told you that you had a $2,000 OR bond if you went out and posted it, and you didn't do it.
I'm going to do it today. I swear I will.
He told you to do it on the 15th of May. This is July the 15th. That's 2 months later. And then he also told you to show up here at the courthouse live on the 15th. And you didn't do that either. And you said you wouldn't be here today at all if your phone hadn't told you to.
I thought it was tomorrow. I swear to God I did.
You called the clerk this morning. Well, I'm still talking. You called the clerk this morning, and you gave the clerk that you thought it was the 15th, that you just woke up at 10 o'clock, not at 9 o'clock when you're supposed to be here.
I woke up at 10 till 9, and I called an attorney, and they want $5,000 to represent me. I need the court to appoint an attorney.
Well, you should have told Judge Crumb that back on May 15th. But then when the clerk tried, sir, you're going to have to listen to me when I talk. When the clerk told you you needed the Zoom codes for today, you didn't have a pen or anything, and you just hung up on her again. You said you'd call back and hung up. So I've got to do something here to get your attention.
You got my attention. I did not hang up. I would not do that. I pushed back up to get rid of the ad on my phone, and it hung up. I don't like phones. I don't do none of this shit.
Well, your phone did you a favor by telling you were late for court. You'd missed it.
No, the clerk did. I called to find out what time court was tomorrow.
All right. Well, we've got a real problem. Do you see that?
Yeah. Yes, ma'am.
And you weren't here when I called your case, and now I've got a bench warrant for you, so I can get you a ride real quick. Are you at home?
No, I'm not. Yes, I am. Yes, I am. I could make it down there today. I've got the gas. I bounced my checking account Friday to get gas for this tomorrow. I did not know. I don't get paid till the 20th, and I'm already $800 overdrafted.
Well, you made a good decision to change your lie when you said you weren't home. Because I figured you were, so it was good that you quickly changed your mind to tell the truth. But we've got a real problem here. Mr. Regier, what do you recommend we do?
Well, Your Honor, as previously indicated on the record, when the court had earlier taken up this matter, my notes from the May 15th hearing before Judge Crum would appear to indicate that the defendant was specifically ordered to appear at the Sally Port, that there may have been certain technical issues at the time, and notwithstanding the court's orders concerning booking and processing, as this is a case that does appear to have
I will be
multiple
down
class.
there today. As soon as I get dressed, I will.
Don't you interrupt him, Mr. Luganbill. You've interrupted me repeatedly. Now you're interrupting Mr. Regier. We don't do that. We follow decorum. Mr. Regier. Finish, please.
Yes, ma'am. You've always been fair with me. Butler County.
Stop talking. Stop
I'm
talking.
sorry.
Mr. Regier is going to talk now. Go ahead, sir.
Thank you, Your Honor. As I was saying, this is a case that, pursuant to the information, does appear to allege multiple Class B misdemeanors, and in addition to Judge Crum's orders from the previous hearing, I am showing an affidavit which would appear to indicate, quote, that as of July 3rd, 2024, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released. And it would also appear that the original first appearance hearing on this case was 2 months to the day. So with that being said, the state will respectfully defer to the court as to how it wishes to proceed. It would appear that the orders previously ordered by district court judge are quite clear in this matter.
Quite clear. And he violated both of them. And this is a marijuana paraphernalia case suggesting the defendant was wandering around the fog line on Santa Fe Lake Road back on November 8th of 2023.
This
Just wonder, and I don't want you to answer this, Mr. Luganbill, but I just wonder if you're maybe on that marijuana today. But that's just a comment. Don't answer it. I don't even know if you were taking marijuana the day of the stop, but that's what the allegations are. Only time and evidence will answer that. But yes, you need an attorney. That's something you should have mentioned to Judge Crum 2 months ago. What kind of work do you do?
I'm retired, ma'am. I'm on a fixed income, and it's not very much.
What are you retired from?
Pardon me?
What are you retired from?
Spirit and Boeing.
Spirit and Boeing.
I make $1,800 a month.
Say that again, please.
$1,800 a month.
$1,800 a month.
Half of what I used to make.
All right. So you knew where we were going. You know how we do this. What do you pay for rent and mortgage?
I paid it off because they're trying to repossess my home.
You paid it off so they wouldn't repossess your home?
Yes, ma'am. I took a hell of a beating on my VIP. I pulled out $50,000.
Haven't you and I had a conversation about this before? Have I seen you on other charges?
No, ma'am.
Okay.
You have not.
Now, the record that I have on my computer goes back to 2012 involving you, but let's move up to something a little more recent, 14, 15. We've got 2018 speeding and insurance dismissed. 2019 supervision of ignition interlock after DUI. So you've had a DUI in there somewhere.
Excuse me?
2021 Okay, so you were a witness in a Joseph McAdoo and a Jonathan Denton. And then in 24 is the case before me. And then in 24 also is, it looks like pending a speeding and a seatbelt charge with the first appearance September 18th of 2024. So have you gotten notice of that new court date?
December the 18th of 2024. What do you mean? Huh?
Well, it says that on June 26th of 24, you evidently got a speeding citation and a seatbelt citation.
I didn't know it was a seatbelt citation, but I know it was a speeding ticket.
And did you know that speeding ticket?
A state trooper.
Did you know that ticket tells you to be in court? Let's see, what did I say?
September.
Looks like he has a court date. Confirm that for me, Savannah, on September 18th of 24 for a new case.
Yes, ma'am. I thought I could just pay it by then, so I understood what he said. I didn't know.
You've got a warrant out for your arrest.
Oh, ma'am.
So do you want them to come pick you up, or can I trust you to turn yourself in? I haven't been able to trust you on anything yet.
Pardon me?
I haven't been able to trust you on anything yet, so maybe I just need to have them go pick you up.
No, I can get a ride there or something, I guess.
I really can't trust you, Mr. Luganville. I guess.
Ma'am, I give you my word. Everything's screwed up. I got diabetes and I got arthritis real bad. I fall every day. I can't hardly walk or nothing. I have a hell of a time. I do. I swear to God.
But yet, you allegedly get out in your car and drive and take marijuana. Well,
no, I don't take marijuana very often because Dr. Varner, which is your
all right. Where is your office, or where is your home?
It's in Douglas, Kansas.
And is your license valid? Is his license valid? Can he even drive right now, Mr. Regier?
Pardon me?
No, not you.
No? I'm sorry. Go ahead.
Do you have a valid license?
Until September, it expires.
Is there anyone with you there who can drive you to court?
Pardon me?
Is there anyone with you who can drive you into the courthouse?
Huh? So Kevin can't. Yeah, probably.
Who's Kevin?
Yes. A friend of mine that does all my labor and everything.
What's Kevin's last name?
I don't know.
Deputy Caulfield?
Yes, ma'am.
Can you see if there's an officer in the Douglas area that can escort him up here?
Yes, I will.
You're going to stay there, and I'm going to send an officer for you. Because I don't know if your intentions are good, if you're confused, if you're just deliberately violating orders, but you need an officer to assist you, and that's to comply with court orders. So I am ordering you to stay put until we see if an officer can be down there and escort you to court.
Okay, I'll get dressed. I don't want my property. I'll meet him at the road.
Well, you can get dressed. I'd urge you to do that, but don't you go running off or getting Kevin to run you off. Any word, deputy, from that, or you need some time?
Yeah, I hadn't asked you.
And I apologize to you. I didn't try to hang up on you.
Well, it was one of the clerks you did. You did a couple months ago, and you did again today. So, all right, we're going to be in recess on Luganville.
What you want to do is save hundreds.
In the USA, people find themselves in court.
Will now be on the record in 2024 CR 218, State of Kansas versus Kevin Lynn Henson. County Attorney Jill Gillette for the state. Kevin Henson. There you are, Mr. Henson.
I don't.
You're Kevin Lynn Henson?
Ma'am, I am.
Sir, in count one, you're accused of interference with a law enforcement officer by unlawfully and knowingly obstructing the officer's enforcement of his official duty, to wit, intentionally trying to initiate a traffic stop on you rather than another driver. What's that saying, Ms. Gillette? Was he trying to cause the officer to stop someone else rather than him? Or was he trying to get the officer's attention off the other car?
He was trying to get the officer's attention off the other car.
Ah,
I remember this one because I read all the affidavits on them all.
okay. Well, if you were to be convicted of that charge, it's a level 9 non-person felony. You could get a sentence anywhere from 5 to 17 months in prison, not the county jail, and you could pay a fine up to $100,000. In count 2, you're looking at a registration and title offense, unlawfully loaning a tag to another vehicle for the driver to use it on a vehicle that was not legally registered. Excuse me. This unclassified misdemeanor carries a maximum fine up to $2,500 and a sentence of 30 days to 6 months in jail. In count 3, you're accused of driving outside the right lane when driving on the inside is required. Sounds like you were driving in the left lane when there were 2 lanes going in the same direction. In that situation, you're always supposed to drive in the right, except for passing or limited circumstances. This is an infraction. It does have a scheduled fine of $75. Mr. Henson, it looks like you've posted a $10,000 professional surety bond to be here today.
Yes, ma'am.
Are you going to be hiring an attorney, or do you need to apply for court appointed?
I was recently laid off. I'm waiting to go back to work hopefully soon, but I do need a court appointed at this moment.
All right. How long have you been unemployed?
Since October 15th, I believe, about 2.5 months.
And where were you laid off from?
Excuse me?
What business were you in?
NOV fiberglass, making fiberglass pipes. I have been working temp service, but I mean, it only pays $12 an hour, just enough, barely enough to cover my bills, not even that.
All right. Be sure and fill out an application. Get that from the deputy before you leave.
May I ask you, ma'am, is this a preliminary hearing, or is this just a charge reading?
This is a charge reading.
When will I be having a preliminary hearing?
Missy's going to give me that here in just a moment. Missy?
Preliminary hearing control will be set January 31st at 1:30.
Now, if you might notice, she said preliminary hearing control.
Judge, can we put that on a misdemeanor day? I think there's a mistake in the charging document.
Yeah, that's what I was going to question, because the charge that I was charged with, the code says that I interfered with a warrant, a writ, or an order of the court. I didn't do any of those things, ma'am.
All right. So what you're saying, Ms. Gillette, is this may be amended to a misdemeanor?
Yes, Your Honor.
Okay. All right. So Missy, let's put that on a misdemeanor docket.
How about January 28th at 3:30.
January 28th at 3:30 by Zoom is your next court date. If you wish to apply for court-appointed attorney, do so.
And how do I do that?
There's a form, ask the officer for an application.
Okay, thank you. I have one other issue, ma'am. So I wasn't even in the same car with a lady, a female that was in a different car, was also stopped at the exact same time. And the bond says that we're not allowed to have contact with each other. But at the time we lived together, we're a couple. So I'm asking, how does that work? How is it that I cannot speak to someone who lives in my home? I mean, she no longer lives in my home. She's had to move out because of this bond, because of this case. And it's cost both money. I can't afford the rent. She can't afford to pay rent over there and rent at my house.
Okay, hang on.
Gillette,
any objection to lifting the no contact?
Judge, they were roommates, and that is the person he intentionally even admitted to the officer that he was trying to direct the attention away from.
As a mom of two boys, having
I didn't do that. I never admitted.
Hang on. Your attorney's not going to want you talking about the case right now.
Okay.
She didn't have an intoxilizer in the vehicle. She was restricted to intox. The vehicle she was driving did not have appropriate tags or paperwork.
So
and he intentionally committed a traffic infraction to draw the attention away from.
No, I did not do that.
Hang on. I presume that's her back there raising her hand.
He admitted it to the officer, and the officer put it in his affidavit.
All right. Well, so are you want him to continue to have no contact?
Well, she may end up being a witness in his case, and she is the person that he was trying to cover for.
All right.
On another crime. So that is the problem.
Thank you. The no contact remains.
I mean, aren't we innocent until proven guilty? How is that we live together? I mean, we did. We're not right now, but she's not going to be a witness against my case because we're going to go to trial.
Did she come into court with you today?
No, she didn't come with me. No, she came on her own. Somebody else gave her a ride here because we have no contact visit. But it's a restraint on my finances and her finances that y'all are putting on us because she can't afford to help me pay rent because she's having to live at another house and pay somebody else rent.
Sir, I'm not doing anything to you. I'm just following the law.
Well, you're the one who put the no contact, right? The prosecutor doesn't have the authority to put a no contact.
I'm the one that's putting the no contact on you, but it's not because of my actions that we're here today.
Well, I thought I was.
You may be innocent. I don't know.
I thought I was innocent.
I'm not going to handle your case. I'm not going to handle your case differently than I typically do. Ms. Gillette has stated the reasons why she would be concerned as a prosecutor.
But even if that's true, how does that keeping us apart now have an effect on that case? Because before we go to trial, our lawyers are going to have to coordinate. We're going to all have to coordinate to go to trial. So what is it? What are you doing to keeping us apart now? What is the benefit of the court for that? It's just benefiting the prosecutor, not anybody else.
Sir, talk to your attorney about that. Your attorney can represent you on that issue. And leave your application and then call back about Friday to my assistant Missy to see if you qualify for court appointed and who your attorney will be until at least the time you get your attorney. I'm leaving that as a condition of your bond.
Okay, thank you.
Judge, you were going to put this on a Tuesday docket. Can you repeat?
I think, Missy, did you put that on January 28th? Is that a Tuesday docket?
Yes, at 3:30.
All right. So, sir, you must be back here with your attorney by Zoom, January 28th at 3:30.
Thank you very much.
You're welcome, sir. You're excused at this time. Well, we just as well bring the friend up here. What's your name? Are you Elizabeth Hoover by chance?
Yes, ma'am.
Excuse me. We are on the record in 24 CR 210 State of Kansas versus Elizabeth Ann Hoover. County Attorney Jill Gillette for the state. The defendant, Elizabeth Ann Hoover, appearing in person and pro se. Ms. Hoover, in count 1, you're charged with unlawful possession of the controlled substance methamphetamine, a level 5 drug felony. If convicted, you could serve 10 to 42 months in prison and pay a fine up to $100,000. In count 2, you're accused of possessing the controlled substance fentanyl. That, if you were convicted, means you could serve another 10 months to 42 months in prison. If these were to be run consecutively, that would be 20 months to 84 months in prison. Your fine again could be up to $100,000 or 200 together. In count 3, you are charged with possession of the controlled substance cocaine, a level 5 drug felony. You could add another 10 to 42 months prison sentence and another $100,000 fine.
Where they're coming up with the cocaine?
Excuse me?
That's when they're coming up with the substance cocaine.
Hello, my name is Adam Ferrari, the Chief Executive.
I'm not hearing you very well.
I would like to know where they came up with the substance cocaine.
Well, they came up with count 1 methamphetamines, count 2 fentanyl, count 3 cocaine.
He told me he didn't know what it was.
Okay, I don't know where they came up with the charges, but that's what they charged you with.
Okay, I'll check it out.
4, you're charged with trafficking contraband in a correctional facility. In this case, they are alleging that you unlawfully and knowingly, without the consent of the administrator of the correctional institution, introduced or attempted to introduce methamphetamine into or upon the grounds of a correctional institution, to wit, the Greenwood County Jail. This is charged as a level 6 non-person felony. If convicted, you could add another 17 to 46-month prison sentence and a fine up to $100,000. In count 5, you are accused of unlawfully and knowingly concealing evidence with intent to prevent or hinder apprehension or prosecution, to wit, concealing baggies of methamphetamine upon your person. This is charged as a level 8 non-person felony. If convicted, you could serve another 7 to 23 months in prison and pay another fine up to $100,000. In count 6, you're accused of operating a motor vehicle not equipped with an ignition interlock device, while your driving privileges were restricted to only driving motor vehicles equipped with such a device following a DUI. This is a Class A.
I was bringing my vehicle home from Missouri, where I used to live before my daughter was taken. And I was stranded in Kansas. I lost my mom last November. I was going to get her car, and I can't get my license back without having the interlock installed on the vehicle. I couldn't get
Your
a car.
attorney would tell you not to talk without the attorney present.
I'm just saying, and I'm sorry for that. But
well, it's not for my protection, it's for yours. You don't have to be sorry to me. I'm just giving you kind of a notice there. Okay, so the circumvention is a Class A non-person misdemeanor. If convicted, you could do 12 months not in prison, but in the county jail, and you could pay a fine up to $2,500. In count 7, you are accused of possession of drug paraphernalia in the form of black bags, syringes, spoon, tinfoil, round plastic container, plastic baggies, and safety pins for the purpose or intent to use, to store, contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body.
That's a whole mouthful.
I'm sorry?
It's a whole mouthful of words all at once.
It is, yes, it is. Class B, non-person misdemeanor, 6 months possible jail sentence up to $1,000 fine if convicted. Count 8, you're accused of operating a motor vehicle without proof of liability insurance, another Class B misdemeanor with up to 6 months jail. It does have a minimum fine that would have to be imposed of at least $300, but could be, I'm sorry?
You said $300?
$300 minimum, up to $1,000 maximum.
And what was that fine for?
That's for the insurance or lack of insurance.
And that was how much?
Anywhere from $300 up to $1,000 in fines.
Okay.
To 6 months in jail.
Okay.
In count 9, you're accused of operating a motor vehicle upon a highway with no valid driver's license. This is another Class B non-person misdemeanor. If convicted, you could serve another 6 months in the county jail, and you could pay another fine up to $1,000. In count 10, you're accused of operating a motor vehicle without a legal tag or expired registration. An unclassified misdemeanor, this has its own special conditions, a fine possible up to $2,500, and a sentence of 30 days up to 6 months possible. Excuse me. In count 11, you are accused of unlawfully and knowingly failing to operate a vehicle in the right lane within 2 lanes of the same direction of traffic. This carries a fine of $75.
So if you hit that 2 p.m. slump every day,
Does not carry jail time.
What did I do?
Excuse me?
Allegedly do? On that last charge?
Okay, I'm still not hearing what you're saying.
Can you repeat the last charge?
Oh,
and
can
what
I repeat it? Sure. That you operated a vehicle in the right lane within 2 lanes going in the same direction.
Yeah, because there was a merge lane and it was going to the one way where it breaks down in down. So yeah, I was. You're right.
Okay. All right. Are you going to hire an attorney or apply for court appointed?
I'm gonna apply for a court appointed, and if I can't, then I will go ahead and hire one for sure. Because
I noticed
on a traffic stop.
I noticed that you posted a $35,000 professional surety bond.
So I did. My mother passed away last November, so I had some money left over from her dying.
So you had money to post your bond, but now you need to.
The last money I had, that was it.
So you used all your money, the last of the money you had on your bondsman, and now you cannot afford an attorney.
I can barely afford rent. 2 houses.
You'll need to fill out an application and check back later in the week to see if you have qualified for court appointed. Your court date will be up next, a preliminary hearing control. Missy, when will that be?
How do I do Zoom?
Yes.
January 31st at 1:30.
January 31st?
Yes.
Okay. Also, if I were to get all of the things like the insurance and all of that stuff done on the vehicle, will that help at all?
Why don't you talk to your attorney about that? The attorney can and will advise you on those kinds of questions.
Okay, because I had an appointment for my interlock the day I got arrested. So.
Okay. All right, well, call back and see if you qualify for court-appointed attorney. If you do not, then you will have to hire an attorney.
That's fine. I'll figure it out either way, one way or another.
I noticed the gentleman before you, this Mr. Henson, posted a $10,000 bond, but is applying for court-appointed, and you posted 35 and are applying for bond. Did you use your mother's inheritance for him as well?
No, he had his own money. That's separate. That's his.
Okay, but you both ran out of money as soon as you paid your bonds.
I just took care of what I needed to get me out. And it was
Okay.
money I
All
had.
right. Anything further, Ms. Gillette, we need to address on this case?
I can't think of anything else, Judge. Thank you. continue the no contact order in her case.
The bond will continue with all existing conditions, including the no contact and no alcohol, no illegal drugs, don't possess, consume, distribute, sell, or anything of that sort. And be back here on the date and time given.
I did get myself into outpatient treatment as well as the mental health stuff this last week.
All right. Thank you, Ms. Hoover. You're excused at this time.
Drinking warm water.
Every word carries weight. Today, we dive into the complex world of courtroom drama, where lives are held in the balance and decisions made can alter futures. This is the story of a man navigating the legal labyrinth, a year of delays, missed opportunities, and the relentless pursuit of resolution. Will justice prevail, or will the cycle of uncertainty continue? Stay tuned as we unravel the truth behind the case of State versus John Kelly Ernest.
Okay, so John Kelly Ernest is here in person and Jared Regier for the state.
Yes, Your
Mr.
Honor.
Ernest, you have one count of DUI. We've had multiple hearings, including a date for bench trial, but that was set over because you were going to hire Matt Levitt. And then you came back on the 24th. You didn't have diversion. You wanted more time to hire Attorney Levitt. Then we came back August 12th and you owed Attorney Levitt $200 more. But if I would just set this over to August 26th, you would appear with your attorney. So what's up?
Yes, Your Honor. Well, the only thing that I didn't realize was that because of my mother's passing, I had missed a week and a half of work due to that situation. And so my paycheck, when I got it, I didn't have enough to finish paying him. So I need this Friday's paycheck to pay him, and then I'm done. Or if you just simply are frustrated with me, Your Honor, I understand, and you just want to go to trial, I'll accept that as well.
Well, I have to admit, I'm frustrated because this is the 5th hearing. You've been telling me you were going to hire counsel.
Yes, Your Honor, I totally understand. I have no issue whatsoever with what you're saying. I knew you would say that. I just did not realize that I would be short a paycheck. I didn't know that. I should have known that, but I didn't.
Counsel from the state, your position?
Well, Your Honor, going back to my notes, in this case, it would appear this matter has been set for bench trial multiple times. First time back in November of 2023, it looks like the defendant failed to appear. The second time, it would appear that back in April of 2024, so maybe 4 or 5 months down the line, it would appear the defendant made certain allegations as he appears to be making today. I, of course, have no personal knowledge as to that. And in the intervening time, it would appear that there's been multiple control hearings since that earlier April 10th date. And
yeah, so a whole lot more. After you started speaking, I found a whole other page.
Yes, Your Honor.
So,
go ahead, Mr. Regier.
So I'm not quite sure how the court wishes to proceed to that. It would appear that this case has remained in limbo for quite some time. If the court will pardon me for editorializing slightly, what I can tell the court is that the state is most eager to reach a resolution in this matter. In reviewing the information, this case does appear to be quickly approaching the 1.5-year age mark. Count 1 of the information does appear to allege a date of March 25th of 2023.
Well, and counsel, we both know from experience that even if he comes up with the 200 and hires Mr. Levitt, Mr. Levitt's going to come in and ask for continuance because he's just been hired.
You know, Your Honor, I would almost just ask you to please just set a trial date, and I will work it out with.
I've done that I've done that multiple times in this case. Then you come in for trial and you're not ready.
Yes, Your Honor. I know my circumstances are less than perfect, and I show up here and I tell you the reality. I can't do anything else. Trust me, I want this resolved as well.
I'm gonna set this over to November 18th, 9 a.m. I'm gonna leave it at status control. Don't think that gives you till November to come up with your 200 to higher limit.
No, I was hoping you'd say an earlier date, but
Yeah, that's what it's gonna be. I want you and Mr. Levitt. I want Mr. Levitt to have time to get his discovery, to talk to you, to get his defense determined and see if he wants a trial or not.
okay, thank you, Your Honor.
There you have it.
All right, thank you.
Continued on bond. Nothing further, Mr. Regier?
Not in this matter, Your Honor.
Thank you, Your Honor.
You're welcome.
Have a great day, everyone.
Okay.
Am I free to go, Your
You
Honor?
can go, Mr. Ernest, but get a hold of that attorney.
Thank you very much.
Jerk me around on this one more time.
Will do. Absolutely.
Is everybody else, Mr. Patterson? Oh, here, Gersh will be on the record in 2020. Thomas on the record in 2024 TR 1098, State of Kansas versus Tajanique Liberty Ronnie Thomas. And I don't know if we have those names in the right order. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Tajanique Thomas. Tajanique, can you make sure and turn your video and audio on? There you go. Thank you. And Judge would announce at this time, pursuant to plea negotiations, Ms. Tajanique would be entering a plea. Well,
Darren, I thought this one was going to be continued.
yeah, it is. And my notes got kind of messed up, Judge. I apologize. This is a case where after talking with her this morning, we are requesting a new date. She's going to provide me further information that will help out in our case.
This matter is continued to November 18th at 8 a.m. Ms. Thomas must be back here at that time. She must stay in touch with her attorney and give him whatever it is that he needs and refers to when he's asking for this to be continued. Ms. Thomas, you'd had some problems before with your Zoom codes and your technology, so make sure you've got that worked out, or you need to be here at the courthouse.
Yes, ma'am.
Anything further from anyone?
Yes, Your Honor. I did just see that on August 13th of this year, I did get an affidavit from the jail stating that the defendant has not gone out to be booked and processed.
All right, now that makes me want to not trust you too much, Miss Thomas. Why in the world do you not respect the court enough to follow its orders?
Regarding what?
To go out and get your picture and prints taken and to post a bond.
Picture and prints? I wasn't aware that I was supposed to.
Well, what were you doing when where was your mind when the court was telling you to go do that? Where was your mind when you went into the breakout room with the officer to set that up? If you weren't aware of it, where was your mind?
To be honest, school. I've been doing school all summer, and I'm currently still a student here at Emporia State. And so I'm doing summer classes, and now I'm in person. So
okay, well, school is important, but so is court. And court, you can go to jail for contempt of court. You can pay fines for contempt of court. You can get that bond revoked and sit in jail for bond revocation. Do you understand that it's serious when a court tells you something?
Yes, ma'am.
Do you need $300? $500?
They're saying that you were driving without a license. There's between that and what you did to the court's orders, it kind of gives the appearance that maybe you don't pay attention to any of the rules or the laws. So maybe you better start paying more attention.
Yes, ma'am.
In fact, August 26th, this morning, you called the clerk and said you didn't have the Zoom codes. They hadn't been sent to you by email. The clerk told you that was because they had no email on file for you. They gave you the Zoom codes over the phone. Later, you called back and you told them you didn't have the Zoom codes, that they kept kicking you out, the ones that they gave you.
No, I didn't say that.
The clerk asked you to write them down again after you told her that apparently you led her to believe you'd written them down the first time and you didn't, or at least you told her the second time you didn't write them down.
No, I called back because my call had dropped because I went into an elevator and I don't have service in the elevator is what happened. So I did call back and asked, can I get signed back in?
Miss Thomas, I'm hearing things that are unacceptable. You're in a predicament. You're in court. You need to make court a priority.
Yes, ma'am.
And the fact that you could not follow the court's order and follow the officer's orders and directions to go out and post a $1,000 bond makes me think that I ought to make you put up cash or surety. Where are you right now?
I'm sorry, I'm at Emporia State University. Got to get ready to go back to class.
Do you want me to send the sheriff to pick you up and you might have to miss class for a while because you can't comply with my orders and officer's directions?
No, ma'am.
I'm all for school. School is huge. It's important. But you can't just go around disregarding laws and court orders and expect to succeed in life doing that.
Yes, ma'am.
Deputy, do we have the deputy for court security one? Are you doing okay? Do you remember Miss Thomas? Did you set up a time for her to go out?
I personally don't remember, but out of the other, yeah, one of us did. But what I can do is our other deputy for scheduling already went to lunch, but I put in the chat everything she needs to do to get this figured out. So I got the jail's number, the address, what she needs to do. So since she failed to do it the first time, everything she needs is to get it done is in this chat that I'm going to send her. So she'll have to be responsible for calling and setting up her next appointment.
Miss Thomas, going out there and getting your picture and prints done it's just basic 101 court order. If you can't even follow that, I'm really afraid to trust you with anything else. But I'm going to give you this one more chance, and you better do whatever it is he's giving you the instructions for.
Yes, ma'am.
All right. If you're going to take on an adult activity of driving and you don't have a license, you're going to have to pay consequences. All right. So be back here November 18th at 8 a.m. and follow up on what he told you to do about that bond. Anything else we need to do?
No, Your Honor.
Mr. Patterson, do we have you appointed to represent her?
I am, Your Honor, and I have talked with her this morning, but I just want to make sure that Ms. Thomas is writing down the information from the chat. I'm concerned that she's not seeing the chat, and if she disconnects, she'll lose it.
Where it says, Hold on, let me reopen it. The phone number, the jail number, and it says schedule printed pictures, ask for Amanda, or leave a message if nobody answers. And then so on.
I couldn't remember. You're gonna have to write that down. I wouldn't expect myself to remember all that. You're gonna have to write it down.
Yes, ma'am. I got it.
Got that quick?
What was that?
You got it that quickly?
I put it in my notes on my phone and set a reminder on my phone as well.
All right. Be sure and call Mr. Patterson or follow whatever directions he gave you too.
All right.
All right, you may go. Being in recess on Thomas, we'll take up Russell Gene Schultz on the record in 2024 TR 177, State of Kansas versus Russell Gene Schultz. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson here on behalf of Russell Schultz. Mr. Schultz does appear via Zoom audio visual. Judge, after talking with Mr. Schultz, he has provided me further information. Would ask to be set over one additional time.
You asked for more ways to
All right, granted to November 18th at 8 a.m. unless the state has an objection.
No, Your Honor.
Mr. Schultz, did you get that date, November 18th at 8 a.m.?
Yes, Your Honor.
All right, thank you. You'll be continued on your bond until then.
Thank you, Your Honor.
You're welcome, and you may go, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, I don't mean to interject or interrupt.
I'm trying to. Go ahead.
Sorry, I don't mean to interrupt or interject. I do have a court matter that I need to attend here in Oklahoma. That's why I'm here about 1 o'clock. And I don't want to interrupt. I'm not trying to be rude. I just don't want to miss that or be on the phone while I'm in court there. Case.
I skipped over your case because Mr. Patterson is not your attorney, and I was trying to get him out of here. But I understand your situation is demanding also. What kind of?
I have a traffic case. I believe that you had gave me a continuance last time to get the license. However, I have two pro quos. Bad news.
Well, let's hold the phone. Hold up. Let me come back to you in just a minute. We'll be on the record in Como. 2024 TR 673, State of Kansas versus Dario E. Como. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Dario Como. Dario Como does appear via Zoom audio visual. Dario Como, can you turn on your video and audio, please? Dario Como. There you go.
Yes.
This is a case where Mr. Como is obtaining further information from me. I think he's done everything, but because he does not have a Kansas driver's license, I'm unable to verify what he's done. So he's required to get me documentation that shows what the current status of his driver's license is.
So you want this moved to November 18th at 8 a.m. also?
If we could, Your Honor.
Mr. Canfield, your response?
No objection, but this is another case where I have an affidavit from the jail, August 13th. The defendant is not reported for booking and processing.
Well, Mr. Como, why should I grant your request if you won't even take my order?
I'm sorry, Your Honor.
I'm inclined to say no. I'm not going to do anything you asked me to when you wouldn't do what I ordered you to do at the last hearing.
I haven't had any money to come down. I'm still in Ohio.
I called a few places to see if I could go and get my pictures and prints scanned here and get it transferred down, but I haven't had any luck with that. I'm currently saving up now. I have an interview actually in 40 minutes here. It's been hard, but I have been applying for other jobs and everything around that I can
Well,
find.
again, you didn't answer my question. Why should I grant you any favors if you can't even follow court orders?
I guess, Your Honor, I'm just asking for a chance.
I gave
right
you a
now.
chance. If you can't follow my very first order, I gave you an OR bond. I didn't even order you to put any money up. Goodness. Well, are you going to have an excuse next time why you didn't do it? If I give you another chance?
For the pictures and prints?
Yeah, and the bond,
Yeah, no, I will not.
you'll get it taken care of.
Yes.
And Your Honor, I did the same thing for this individual. I sent a chat with all the information. Yes, so
All
you'll
right.
need to check your chat.
Could we have another one in a breakout room after this? Because I actually lost the notebook that it was in because I just moved and we lost a couple boxes in the moving process.
Do you see a chat that you just received on your phone?
Let me see. Where at? Sorry. On like Messenger or?
Be on your Zoom. There should be, maybe if you run your finger across the bottom of your phone or down the side, there'll be some
Yeah.
buttons pop up. Do you see one that says chat? It might be.
Yeah.
highlighted. Okay. Click on that. You see it?
Oh, okay.
So make sure you write all that information down before you exit off of Zoom because it'll go away. So make sure you're writing that down.
All right. I took a couple screenshots of it.
Okay. And then be back here November 18th at 8 a.m.
On Christmas morning, if your kid wakes up to this game stick, it's gonna be their favorite present.
Did he get lost in the box in the move too?
Yeah. It was in the notebook.
Do you think you ought to give him his phone number if he's going to represent you?
Pretty please. Thank you.
No, I think we sent you an email to be on this hearing. And that email has all my information on it. It gave you a link to get on this Zoom hearing.
I haven't. Who is it sent by? Would I just look up your name?
It is under my name, Darren K. Patterson, attorney at law, under my email, DKP Law. Didn't you use that to get on this hearing?
I couldn't find anything. I actually got from my old case, and then when I couldn't get on, I called the court office, gave them my case number, and got onto there.
Well, why don't you write this down? 316.
Right. 316.
322.
322.
7700.
All right.
Call that at 1 o'clock. Give us all of your information and we'll trade back.
Okay. Thank you so much.
Okay. get those pictures and prints and bond made now. All right, you may go. Thank you.
Every day in the USA, people find themselves in court.
Now we'll take up the gentleman at the jail, Brian Trober.
Yes, Judge.
Okay.
Long time no see.
Okay. I thought, Mr. Trober, you might be appearing from Missouri. Are you still in custody in Missouri?
No, Your Honor.
Good.
I was released from prison in Missouri on November 11th, and I had this warrant over here. So I was picked up by St. Louis County, Missouri, waived extradition, and was brought over here on Friday evening. If I may speak about the history of this case was previously filed under a different case number last year. I sat here for a couple months. You reduced my bond to $5,000. I was able to work it out through a bondsman for 10%. I had the warrant in Missouri for my prison case over there. I had an extradition hearing. I waived extradition. I went to Missouri. I've been in custody since I've been over there. I believe it was this past June. You dismissed the case, something to do with the labs not being back. The Miss Gillette refiled the case in July. We noticed on the portal online that it was refiled, and I had a first appearance scheduled for August. So I did everything in my power. I went to my case manager at the prison.
We're Phoenix Energy, a family-owned oil company focused on
Records said the court clerk had to contact the prison. I got on the phone to my family. My family contacted the Greenwood court clerk, notified them. Greenwood court clerk notified the prison. And the prison told me, we don't do Zoom. We don't have Zoom. All we have is Blue Jeans. Despite my arguments about an app on their desktop, I wasn't able to make first appearance. I did send a letter of incarceration over from DOC, which on the portal, it shows that the court's received on the 8th of November.
All right, Mr. Trober, I do have a copy of the complaint in front of me, complaint and information filed July 16th of 24. And in count 1, the state is alleging unlawful possession of the controlled substance methamphetamine, a level 5 drug felony, which carries a sentence, if you were to be convicted, 10 months up to 42 months in prison and up to $100,000 fine. It is alleged that that crime occurred on August 5th of 2023, as you said, over a year ago. And count 2, you're accused of theft of a 2006 Ford F-250 with a value between $1,500 and $25,000. It doesn't allege who the owner was, but it's filed as a level 9 person felony, which means if you were convicted, you could serve anywhere from 5 to 17 months in DOC and pay up to $100,000. In count 3, you're accused of unlawful possession of a vape pen, rolling papers, spoon, and metal container for the purposes of storing or containing, ingesting a controlled substance. That's a B non-person misdemeanor. That means the sentence would be to the county jail and could be up to 6 months. On count 4, you're accused of driving while suspended. This is a B misdemeanor. The fine is anywhere from $100 to $1,000, and the sentence could be up to 6 months in the county jail. Count 5 is charged as operating a motor vehicle without proof of liability insurance, another B misdemeanor. Its minimum fine required, if convicted, is $300 and could be again up to $1,000 and 6 months in jail. Count 6 accuses you of unlawful possession of the controlled substance marijuana, or THC, and it's a Class B non-person misdemeanor. 6 months possible jail sentence, $1,000 possible fine. Count 7 accuses you of transporting in a moving automobile a container of, 2 bottles of Fireball, an alcoholic beverage, and that is charged as an unclassified misdemeanor. The penalty can be anywhere up to $200 in fines and anywhere from 30 days to 6 months in jail. In count 8, you are accused of operating a vehicle that was not registered on the highway or roadways of the county. This is an unclassified misdemeanor. It has special penalties. The fine could be up to $2,500. The sentence could be 30 days to 6 months. Count 9, you're accused of speeding 86 in a 65 mile per hour construction zone. This is a scheduled fine. It does not carry jail time. The construction zone doubles the fine. So those are the charges you're looking at. And are you going to be hiring an attorney or applying for a court appointed?
Your Honor, I'll apply for court appointed, and I ask that Richard Paul be reappointed since he's familiar with the case and I've already worked with him on it.
All right, Ms. Gillette, what has the state to say about this unusual predicament?
He's had a lot of holds everywhere. He just has a lot of different cases that have been everywhere. I do have a wonder if he's gonna grab more cases or run. I mean, he's had holds from everywhere to have to go take care of, and that shows a long history of failing to comply with bond conditions and failing to appear. I would ask for a $40,000 cash or professional surety.
Your Honor, if I may speak.
Go ahead.
I was previously incarcerated in this case here in Greenwood County. My bond was initially set at $25,000. I sat in jail for some time. You had reduced it to $5,000, and that's what I was able to post on through a bondsman. The cases that she's talking about, as far as everywhere, were Wyandotte County, Johnson County, and then Clay County, Missouri, which are all within a 30-mile radius of each other, except for Shawnee County, which was 40 minutes down the highway. So it's not as if I'm just all over the place. It's really within a 30-mile travel radius.
As a mom of 2 boys, having health insurance is extremely important. I am beyond thankful of having coverage through healthcare.gov. It covers all of our doctor's appointments, including emergency care.
Healthcare.gov. Enroll by January 15th.
Never, ever sue the driver who crashed into you after a car accident. There's a better way to get compensated that's faster, easier, and could get you way more money without spending years in court or paying expensive lawyers up front. If you've been in a car accident within the past year, even if you were just a passenger, what I'm about to share could save you months of hassle and put tens or even hundreds of thousands more in your pocket. Here's what most people do. They either accept whatever small check insurance sends them, or they hire a lawyer up front and prepare for a long, expensive legal battle. Both options leave you frustrated and underpaid. But some accident victims are discovering a completely different approach, one that could get them 6 or 7-figure settlements without ever suing anyone or stepping into a courtroom. It's called the 2025 Crash Connect Compensation Program, and it was created specifically to help accident victims get maximum compensation without the nightmare of lawsuits, upfront legal fees, or insurance company runarounds. They're currently looking for 10 more car accident victims to try the program at no cost and receive their full compensation quickly. Check in seconds if you qualify for the program by clicking the link around this video and find out if you could be owed a bigger check. Take Derek's experience. Everyone told him suing was his only option to get real money. His lawyer quoted him $8,000 up front and warned the case would take at least a year, maybe longer. Derek decided to check if he qualified for the Crash Connect program first. He received $130,000 in 42 days without suing anyone or paying legal fees up front. Here's how it works. Click the link on this video to access the qualification tool. You'll answer 4 basic multiple choice questions about what happened. No legal terminology, nothing complicated. Takes roughly 30 seconds and checking is 100% free. Once you qualify, an accident specialist contacts you directly. You walk them through your accident details, then they take over completely. No lawsuits, no court appearances, no dealing with insurance back and forth. Your settlement check could arrive in 30 days or less. And here's what makes this risk-free. You pay absolutely nothing unless you actually get compensated. Nobody can reverse what happened to you, but this program makes certain you receive every dollar you're owed for medical expenses, missed work, vehicle repairs, and everything else without putting your life on hold for a lawsuit. What would $80,000, $120,000, or even $150,000 do for you today? Clear out those medical bills that keep growing. Get a reliable vehicle again. Stop living with constant financial anxiety and actually start recovering. That money is yours for the claiming. Here's the reality about lawsuits. They sound like the right thing to do, but they're usually just the most painful way to get compensated. While you're stuck in court proceedings for months, dealing with continuances and legal fees, other people are
Last time we seen each other, you agreed that 5,000 was sufficient, and I posted on it. Since I've been
But then you failed to appear again.
only because I was in custody. You knew,
That's not generally a very good excuse.
Your Honor, this is my first time ever having a failure to appear while I was in custody. I've never been on bond in any of my cases and violated the terms of my bond. I've never violated any terms or conditions of any of my bonds anytime.
Ms. Gillette, are you seeing any failures to appear on there?
Judge, not breaking the law is a condition of bond. He's had cases all over the place on these cases. He's had Wyandotte, Shawnee, Johnson, Greenwood, Missouri. His case history goes back to when he was a kid. His criminal history goes back to when he was a kid. I think the earliest I've seen is 2008 and 2007. And it's been consistent except for when he's in jail. And he's been in another state waiting to be extradited back to Kansas. I'm asking for a $40,000 cash or surety bond. Him saying how many times he's been in jail and where all he's been had to move to take care of probation violations, getting his cases finished, getting his cases pled across 2 states is not helping me want to change. I initially wanted to say $50,000, but I said 40 instead because he's here finally.
Well, thank you. What I'm going to do is set it at 40,000, Mr. Trober.
Your Honor, may I ask what circumstances have changed since my last bond modification hearing?
Well, what has happened is you failed to appear.
Because I was still incarcerated.
And Ms. Gillette has just given me a list of cases that I may or may not have considered last time.
Ms. Gillette
The
was very...
sheriff has had to incur the expense of sending equipment and manpower to Missouri. So I'm going to leave it at 40,000, and then you contact Mr. Paul, and he may be able to convince me to modify it, but that's where we're going to start.
Yes, Judge.
Okay, thank you. Deputy, if you'll make sure he gets the opportunity to call his attorney. Of course, let Missy check though, make sure Mr. Paul will take it and that she'll have to reappoint him.
Okay.
All right, thank you. But by the end of the week, this is Tuesday, certainly by Thursday or Friday, you'll know for sure where you stand on that.
Yeah.
We are on the record in 2024 CR 132, State of Kansas versus Brian Lee Tober, County Attorney Jill Gillette for the state. The defendant appears in person, in custody, and with counsel William McClendon. Mr. McClendon, how does your client wish to proceed?
Judge, I filed a motion for bond reduction. I believe yesterday, or it might have been Wednesday evening, but not approved till yesterday. I was wondering if we could be heard on that.
Well, you can be heard on that, but before we proceed to it, what about his preliminary hearing?
Judge, I'm even newer to this case. I think I was appointed earlier this week, but Mr. Trober's been pretty proactive in trying to be able to get out on bond, and that's why we're here today.
All right, the matter will be continued to 1:30, December 20th.
And technically, Judge, we had it set for a different date, and we just put it on here for the bond motion.
Okay, all right, bond motion only. Go ahead and proceed, Mr. McClendon, on your motion.
Judge, as you're probably aware of this case, probably more than even I am, this case was previously filed and then it was dismissed. Sorry, you keep moving around on my screen. Then it was dismissed without prejudice, without prejudice. And so the defendant lost his bond. He lost his attorney, which was Mr. Paul. And then due to his incarceration, he wasn't able to show up when this case was first issued. So he has a failure to appear. I believe his bond set at $40,000. His prior bond in the old case was $5,000, and we'd be asking for a bond reduction down to $5,000.
Was it charged originally as a felony or misdemeanor? That prior
I don't know, Judge.
Judge,
It was originally a felony.
Previously, we were waiting on the KBI labs, and since the KBI labs weren't in yet, you dismissed it without prejudice. It's one of those cases that got caught in that time period where the labs were very far behind because of the move of Pittsburgh.
My husband used to ejaculate prematurely until this.
Okay.
And then the lapse came in 1 or 2 days after the dismissal without prejudice. And so I refiled. And by that time, he was in the Missouri Department of Corrections and actually appeared from there at one point, or tried to get him to appear from there at one point, and we had to end up waiting with a no bond hold.
All right, the motion to, where are you living when you're not in custody, sir?
Wichita, Kansas.
And with whom?
A friend of mine.
Who's your friend?
Marcus
Marcus.
Smith.
Does Marcus have any criminal charges?
Not that I'm aware of.
Have you ever lived with him before?
Well, I had leased an apartment in Wichita before my arrest here, and he was able to take over the lease.
Is he a drug dealer, a drug user?
No.
Well, since he appeared before on the bond, as I understand it.
Well, we had a lot of issues with Mr. Trober. Mr. Trober is the one who had cases in Wyandotte, Johnson, everywhere in Missouri. He hadn't finished his cases, had multiple cases, was missing those cases, had warrants, had tons of holds. We just got him back from the Missouri, I believe it was Missouri Department of, but he's been all over. So we set it at 40,000 cash for professional surety to ensure if he left to another state that he would have sufficient reason to bring him back and to find him, because he has been everywhere. We've been waiting for multiple other states and counties to take care of their cases on him. And that he's just been all over, racking up cases all over. And I would wager to say that Mr. Trober caused a bulk of his own problems by having cases out of Roland Park, Kansas, Olathe, Kansas, Kansas City, Kansas.
How long ago were those? Are they still pending?
Judge, he's trying to wrap up most of his cases everywhere he's got. I think we're one of the last places to have him finally.
Well,
This is his only open and pending case, Judge.
That's what I thought he told me, was it last week or whenever I saw him.
Your Honor, if I may input real quick, I only had one case when I left here last year on an extradition hearing, and that was Missouri. And I've been in Missouri until I came back over here. I only had the one case, and that was a case from 2019. I just had to go finish my prison sentence on it.
All right, but you don't have anything pending anywhere that you know of.
I have no charges pending anywhere else.
All right, Ms. Gillette, I think we interrupted you. Did you have anything else?
Yeah, Judge. I mean, he racked up a lot quickly, and I know
What time frame?
he has cases from 2018 from Johnson County. He has 2020 in Johnson County decisions, 2018 decisions, 2022 in Wyandotte County. Like, he wrapped up one case after another, and then came down here to Greenwood and had our case. And it's just been one case after another. Plus, he had the other case outstanding that he had to go take care of in Missouri. So he had a lot of cases to get caught up, get resolved, get himself back in place. But he moves around so quickly that he's just racked up all this stuff. Again, if he decides to leave the state, I want sufficient cash or professional surety to bring him back here.
Mr. Trober, you said when you get out, you live in Wichita. Where have you lived mostly during your life?
Kansas City metropolitan area. All of them other jurisdictions are mostly in the Kansas City metropolitan area, except for Shawnee County, which are 40 minutes down the road.
What kind of charges were those?
I've had possession of firearm by convicted felon, theft charges.
Burglary?
I have a second-degree non-person burglary out of Missouri from 2019.
Okay.
All of those cases are from 2019 because an amended complaint was filed.
Okay.
I haven't been in trouble since 2019.
Are you going to have a job when you get out?
Yeah, I'm going to be working at the Restoration and Waterproofing Contractors, Inc. I used to work for them out of Topeka, and they're headquartered in Wichita. So my old boss told me just go in and apply and list him as a reference, and I'll get right on. So.
I will modify your bond to $5,000, but you must wear EMD. And you're not to leave the state of Kansas.
Hey, what is EMD?
That's that ankle monitor that tells me where you are. And keep it charged. I don't want any of this. The battery died. I didn't know it wasn't plugged in, whatever. The jail will have a number you can call for that. You'll have to pay for it, and I don't know how expensive it is, and I don't want to hear you griping that it's uncomfortable when you work and all of that. Because that's what I usually hear. But if you want out, if you want your bond down that low with everything that's been going on, then you're going to wear the bracelet and you're going to comply with all the rules for it.
Yes, Judge.
Anything else?
I'm thinking of anything else.
All right, we'll be in recess. You may go, sir.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome. That's your last one, Mr. McClendon?
Yes, it is, Judge.
I usually dress.
Will now be on the record in 23 TR 2777, State of Kansas versus Anthony Edward Dubas. Jared Regier for the state. Is Mr. Dubas present? Anthony Dubas?
I am Anthony Edward Dubus. Dubus is the English pronunciation. Dubus is the original French. And I am appearing specially in propria persona, not pro se, as sui juris.
Okay, first of all, I can't see you, so you're not here.
Parent satisfied?
Thank you, sir. Now,
Absolutely.
as far as I need to go, well, I need you back here in person.
Okay, well, it's propria persona, not in person. I'm not the legal entity that you're claiming me to be.
All right, sir, if I can't get you on camera, you're not here.
I'm doing so right now. I'm just removing it as it takes a while.
Now, the second order of business, let's get your name straight. I know a family with the same exact spelling in America, and they do pronounce it Dubus, but you said you pronounce it
Dubus,
Dubus?
as the original Dubus, as the original French. Yep.
Very well, Dubus.
Thank you.
Now, you're welcome. Now, Mr. DeBoos appears in person and pro se.
Correction, proprietary persona.
Well, in this court, it's in person. And
Correction, in all courts, it may be either pro se, either appear in person, or proprietary persona.
well, in my years of law school and nearly 40 years of practice, both as an attorney and a judge, it's been in person, and that's what I'm going with, sir. I believe that is just fine. So in any event, we will proceed with your charges. In count one, sir, you're charged with, on August 17th, 2023, in Butler County, Kansas, operating a motor vehicle on a highway of this state without having a valid driver's license pursuant to KSA 8-235A. No valid driver's license is a Class B non-person misdemeanor. And that means that if you were to be convicted, your sentence could be up to 6 months in the county jail, and your fine could be up to $1,000. In count two, it is alleged that on or about the 17th day of August, 2023, in Butler County, Kansas, you did then and there unlawfully operate or attempt to operate a motor vehicle, to wit, a 2003 Honda Accord, upon a highway of the state, to wit, 1700 block of East Foxdale Street, Andover, Butler County, Kansas, while the vehicle was not registered in violation of KSA 8-142. Failing to register a vehicle as alleged here by the state is an unclassified non-person misdemeanor. It has its own special penalties of a fine as high potentially of $2,500 and a jail sentence potentially anywhere from 30 days to 6 months. In count three, it is alleged that on or about the 17th day of August, 2023, in Butler County, Kansas, Anthony Edward Dubus,
Thank you,
did
Maya.
then and there unlawfully and intentionally drive a motor vehicle upon a public highway or property open to use by the public and failed to provide proof of insurance upon demand by a law enforcement officer. Now, sir, if you had insurance when you were stopped but just didn't have it with you or couldn't find it quickly, just provide proof to the county attorney and they'll most likely dismiss that charge. But if you really didn't have insurance, you're looking at a Class B non-person misdemeanor. The law does require a minimum fine if you're convicted of $300 up to $1,000, and it does have a possible jail sentence up to 6 months. Those are the charges against you. You do have the right to an attorney. You can hire any attorney of your choice, but if you cannot afford an attorney, you can apply and see if you qualify for a court-appointed attorney. You don't have to have an attorney, though. You can waive your right to an attorney and represent yourself. So that's an order of business we need to take care of today, is whether you want an attorney or not. And then another is to make sure that you understand what the charges are and the possible penalties. Do you have any questions for me about that?
Yeah, I don't understand the nature and cause of the charges. I have not had my accuser face me to bring the charges against me, as is a violation of due process. And I want to correct, for the record of the court, the named defendant is different than the named person, being myself. Hold on, let me make sure I get that in view of the camera. The named person here is different than the one named in the charges and the counts.
Hey guys, I made this quick review video for my subscribers to let you know about a great survival resource that I'm giving away for free for the next few days. There's so many survival videos out there trying to get you to buy crap, but this is something that you can get without spending a dime. The book is called Alone
being a difference of representation of who exactly it is the charges are against. And it is to my belief and knowledge that per KAR 8243 subsection A, exemption from the motor carrier safety regulations, A, the occasional transportation of personal property by private motor carriers that is not for compensation and is not in the furtherance of a commercial enterprise. I am exempt from these rules and regulations, and if I need to get a US DOT number to show that I was not operating a commercial motor vehicle or as a common carrier for business or for profit or in the furtherance of a commercial enterprise, I will be more than happy to produce that US DOT number to show that I am in fact a private motor carrier, not operating in commerce, not driving as I'm merely transporting and traveling.
Mr. DuBois, you are not charged under the Uniform Commercial Carriers Code as adopted by the state of Kansas. You are charged just as a motorist operating a motor vehicle. Again, not a commercial vehicle. These are not laws that are subject to the commercial code or to the administrative regulation that you referred.
Although you mentioned the word operating, operating is a term used for the commercial furtherance of a commercial enterprise, or driving, operating, the physical use or furtherance of for-profit business or for compensation.
It may under the commercial code, but not under the code otherwise.
It is under Kansas, correct?
It is not under Chapter 8 of the Kansas statutes or Chapter 40, which are filed under. But we can address that at a later date at a trial or a motions hearing if necessary. But I do not see the statutory language that you're addressing being applicable to these statutes, at least preliminarily at this hearing.
It is within, sorry.
Okay.
Go ahead.
That's my ruling there. And then on the name issue, I am not tracking you there. The only difference I see is that at the top of the document, state of Kansas and your name are capitalized, and in the initial or in the individual charges, it's traditional capital letter of the first name, all lowercase of the remaining names throughout. So I'm not following that argument. Again, if you want to readdress that at a later date, we can, but I'm just not seeing that argument.
Okay.
Now
then. I motion and move this court to dismiss this case for the motion I have filed and for the brief in support of motion to dismiss for lack of jurisdiction.
Sir, I do not have any such motion or brief in support. Mr. Regier, have you received any such documents?
Not to my knowledge, Your Honor, and so I fail to see, at least at this juncture, how such a motion is properly brought before the court, unless the court is aware of something that I am not aware of.
Well, that's what I'm trying to decide, if it's properly before the court. Mr. DuBois, who did you file the motion and brief with?
Well, seeing as your guys' e-file is down for what is it? It's called a ransom malware or something. I cannot e-file.
Right,
so
but you can mail it, or you can walk it into the clerk of the court. Have you done that?
Yes, I've mailed it by email, which a
and
court
I'm sorry,
clerk
but I
said I could.
Go ahead, please. I'm sorry I interrupted you.
No, you're fine. It was by email, which the court clerk said I could, considering the e-file was down. And I can't really go 20-something miles to do that, considering my personal property was stolen.
When did you email it? Sir, when did you email it?
A while ago.
Judge,
Yeah.
Yes.
we do not accept emailed filings, only faxed or by mail or person.
Okay,
I'm
I was
sorry.
told that they do not have fax, so I could not do that. So email would be okay.
He may have called the wrong courthouse then.
They spent 10 minutes finding my case because your guys' system was down. So I'm fairly certain it was the correct one.
Okay. Do you recall which you filed or which court you called?
Let me go to my sent.
This doctor analyzed the most common breakfast foods and discovered what helps your waistline and what's draining your energy.
Eggs? If you're going to get eggs, these are the kind to get, the pasture-raised eggs. Oatmeal? This is one of the worst things you can have for breakfast. Almost all oats in the United States test positive for Roundup, glyphosate, which is a major gut disruptor. Oats are one of the best ways to fatten you up that I've ever seen. Orange juice? This is poison in a carton. It's pure sugar. Avocados? Now, an avocado, mostly pure monounsaturated fat like olive oil and fiber, which your gut buddies love. Human studies show that eating one avocado a day will help you lose weight. A lot of people are surprised that most of our weight loss or gain is actually controlled by the bug.
tstafford@bucokansas.com.
I think that might be at the county courthouse, not the district courthouse.
Okay. So
Is
if
it?
you want,
Okay.
if you want to file something, sir, let's make sure you file it in a fashion that will get it officially recognized. So Ashley, how do you suggest he file motions and the like?
He will either need to mail us a copy of it or he can fax file.
And is your guys' fax active?
Yes, it has been the whole time.
Okay.
It's
And
not affected, yes.
what's the fax number?
Our fax number is 316-321-9486.
Okay. And my honor, I have one last question. For the nature and cause of these charges, is it a criminal or is it a civil matter?
This is a criminal matter.
Okay. As is a criminal matter, there are two jurisdictions which I may be tried. One is the common law, and the other is a military tribunal. Which of those two do you intend to try me in?
I intend to try you in this one, sir.
Which is this one? Please elaborate.
The criminal one.
Well, criminal has two jurisdictions. It is either the common law or it is the military tribunal.
Well, sir, we're not going to go into that at this point.
Are you refusing to acknowledge to me and tell me the nature and cause of the charges?
I have told you the nature and the cause of the charges.
You are not elaborating.
I think the remaining issue, sir, is whether you're going to hire an attorney, apply for court appointed, or represent yourself.
My honor, I need to know whether or not this is going to be in the common law or a military tribunal.
Well, I am going to ask you one more time. Are you going to hire an attorney, apply for court appointed, or represent yourself, sir?
Again, I'm not representing myself. I am sui juris in proper persona and propria persona.
So you're not going to have an attorney, or are you?
No, I'm not going to be presented or represented by any British agent, registrant, or anybody else to be a ward of the state. I'm standing on my rights and I do not abrogate them. And if you're going to continue to move this court without any sort of evidence, well, I guess I'll have to file that. But
We're going to set your hearing. How do you want to plead to the charges first? Then, if you don't want to have an attorney, how do you want to plead to no valid driver's license?
My Honor, are you attempting to administer the trust without permission and consent?
I'm asking you for your response. I'm giving you the chance to respond. Do you want to plead to this charge or not?
My Honor, I don't make any pleas as I am appearing in proprietary persona, and any plea would submit jurisdiction to the court. I am here challenging jurisdiction under the common law as I am owed the law of peace. And this is a fraud action as fraud in the inducement from the beginning under due process violations from Deputy Khalid Baraka and the other officers or sheriffs that were on scene. And if you're attempting to administer the trust without consent of myself, the living man, the grantor, in common law, which is above Admiralty Maritime law, then you will be in violation of Article 3, Section 2, the trial of all crimes, except in case of impeachment, shall be jury, and such trial shall be held in a state where said crime shall have been committed, but when they are not committed with any state, the trial shall be at such place or places as the Congress may by law have directed. And as there is a difference between the Republic State Kansas before the state of Kansas was brought into the Federation of the Union of States. And you will also be in violation of
I am. This is you, the listener. I'm frustrated.
I'm getting it real quick. 18 U.S. Code sections 2381, treason. Whoever owing allegiance to the United States, the corporation, not United States of America or for America, levies war against them or adheres to the enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. Now, I, Anthony Edward Dubus, the proper case trade name, not the all caps legal entity of which you're attempting to administer the trust of, am an American state national, a Kansas state national per 8 USC 1101 subsection 21, and is recognized by the Kansas Human Rights Commission as I have dealings with them going over my nationality in regards to a corporation in which I have a complaint filed against, has already been refused mediation by the company and is being investigated by Barbara Carper, the special investigator of Kansas Human Rights Commission, over my case specifically. And if you are attempting to move this case against myself, you are in violation of executing law rather than just judging on it. Which, if I need to pull up that statute
Sir, do you,
case as well.
sir, do you still have the same phone number you had posted on your bond that you have with AAA Butler County Bail Bonds? Is that still your current phone number?
My Honor, Mrs.
316-252?
My Honor, Webster, it is, you may call me either Anthony Dubus or Anthony Edward Dubus. I do not accept the term sir. Although,
well.
Yes, my phone number is still the same at 316. 252-9724.
Right. And is your address, okay, addresses I found needs to be blocked. And Mr. Dubois, is your address still homeless, or do you have something more specific at this time?
See, they refuse to put down my address. I am within Wichita, Kansas, rural free delivery within the 4-corner rule 67202, aka the brackets around 67202. And they refused to put down my rural free delivery address and put me as homeless instead because they could not accept it. They refused. Also, Deputy Khalid Barakay, when I was taken to Butler County Detention Center, refused that there were any magistrates at all within any of the courts, which per due process of common law, I was to be taken before a magistrate or a tribunal, both judicial, either Article 3 or 4, in front of a magistrate judge to be decided whether or not I was even within the jurisdiction to be tried for these charges or commercial crimes.
Your next court date will be 2 weeks from Monday. What do you have, Ashley? 2 weeks from this past Monday. What is it?
I believe that is going to be Monday, the 18th.
All right, Mr. Dubois, your next court date is December 18th at 8 a.m. by Zoom. You can always appear in the courthouse personally if you like. I am appointing Attorney Darren Patterson. Now, if you don't want to use him,
I do not accept any appointment of any attorney.
But I show that you don't have a specific residence. Do you have a job, employment?
I did, and then these actions against myself from the state of Kansas caused me not to have it anymore, which I am in process of finding another one, putting in applications every day and making sure I do my due diligence to make sure that I can gain my compensation and my livable wage.
Well, your attorney is Darren Patterson. His number is 316-322-7700. Ashley, please send him Mr. Patterson, the appointment and the court date. I want you two to talk. If he can be of any service to you, I would encourage you to let him do so. If you have any questions or if you want him to help you with any motions, he can advise you on that. But I think at this point, there is a lot of confusion on your part about
no, there's no confusion
and how it works. Did you
I've
go to
researched
law school,
more than
Mr. Dubois? Did you go to law school? Are you a licensed attorney?
it is Anthony Dubois or Anthony Edward Dubois. No, I am not a licensed practice attorney, although that does not stop the common law right of anybody practicing law for themselves, or not practicing, as that is the commercial term, enacting law and being in court for themselves, on behalf of themselves, and to have any form of counsel they deem necessary.
All right, we do have finally a point we agree on, that you don't have to have counsel. But I want Mr. Patterson available to you because you have, in this court's opinion, mixed federal law and state law and other sources of law that don't all go together.
May I elaborate?
I just want him to be available to you. I think we have exhausted this particular hearing, the purpose of which is merely to make sure you know what the charges are, the possible penalties, and your rights that I have gone over with you, including your right to counsel, which I'm hearing you say you don't wish to utilize. But nevertheless, I'm going to direct Mr. Patterson to at least be available to you, that you be here again December 18th at 8 a.m. by Zoom, and I'm going to continue your bond until that date and time. So anything else, Mr. Anthony Edward Dubois, please
Thank
take
you,
that
Your
up.
Honor.
Thank you. Please take that up at the next hearing after you've had a time to talk to Mr. Patterson.
Okay, my final thing I want to say is I'm already filing Kansas Commission on Judicial Conduct complaint against the judge. And that would be the prior judge, Mr. Mr. Lee, I believe. And I will be adding you to the complaint as well, as you are violating my due process right and my Sixth Amendment right.
Well, you're welcome to do that, sir, if you want, but at this time, this hearing is adjourned.
Okay, and I also want to mention that Mr. Regier has not moved this case against myself, and that the witness, firsthand witness that needs to be present to move this case against myself is not present.
Your
And is a
arguments,
violation of my Sixth Amendment. I yield.
your arguments are noted, and we are in recess. You are excused at this time, Mr. Anthony Edward Dubois.
Dubois, thank you. My honor.
Dubois, I will get it, Dubois.
You're fine.
Wow, these southern citizens, these guys are idiots. I swear to God. They have no concept of law or the court process. Oh my God. I think Judge Webster handled that pretty well. Well, that's it for today, ladies and gentlemen. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. So you all have a wonderful rest of your evening. I'll see you tomorrow. Ta-ta and ciao ciao.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.